South Africa should have tried to determine whether the court's request to arrest and surrender Mr. al-Bashir was obliged it to act accordingly under its obligations. However, South Africa did not do so. The conditions provided for in Article 98.1 have been met because of Sudan's prior accession to the Genocide Convention. Consequently, South Africa would not have acted in an inconsistent manner with its obligations under international law when it comes to the immunity of a person from a third state, as set out under Article 98 of. This would not have been incompatible if South Africa had arrested Omar al-Bashir and surrendered him to the court. Mr. al-Bashir's immunity was lifted because of Sudan's accession to the Genocide Convention. In light of the horizontal dealings between Sudan and South Africa, there was no hindrance to the court's request to arrest and surrender Omar al-Bashir. By not proceeding with the arrest of Omar al-Bashir, South Africa failed to comply with its obligation under the statute. However, I do believe that it is necessary to make a number of additional points by way of an attentive reading of the various legal positions that were taken before the Chamber. The legal foundations of the Chamber's conclusions are extremely important. I do not entirely agree with certain points taken by the majority, and I believe a more detailed analysis is needed. My individual minority decision, or opinion rather, will deal with a number of issues. Did the referral by the Security Council place Sudan in a position identical to that of a states party, thus leading to the lifting of al-Bashir's immunity under Article 27 of the statute? In this regard, if one reviews the various submissions made by the prosecution and the submissions of South Africa, one sees that the various submissions are supported by certain elements of the statute, by doctrine, and that in both cases some elements are valid. In light of the divergences between these various submissions, it is not possible to draw clear-cut conclusions regarding the issue of whether or not the referral by the Security Council of Darfur situation to the court placed Sudan in a situation equivalent to that of a state party to the statute. And issues that deal with...
We're now joined on the line by Netsanet Belay, Africa Program Director at Amnesty International. Good afternoon and welcome. What does it mean for South Africa? Just taking us through this ruling.
Thank you very much. Well, as you may have heard, the court just handed out its ruling, effectively affirming what we all have said before, that South Africa indeed had failed to fulfill its obligation under the Rome Statute by failing to execute the court's cooperation request to arrest and surrender Omar al-Bashir. So that is unequivocally established by all judges unanimously. And the judges have also unanimously agreed that despite the failure of South African government to arrest and surrender Omar al-Bashir, the judges found it ineffective to refer South Africa to the UN Security Council or the Assembly of State Parties, given the fact that they believe the matter has been conclusively dealt with both domestically and internationally, that is in terms of clarifying any ambiguity about South Africa's obligation. And secondly, and rightfully so, seeing the number of examples where the UN Security Council has failed to take action on member states who have failed to execute the ICC's arrest warrants, and specifically in relation to Omar al-Bashir. And they did point out their regrets and disappointment in the UN Security Council's failures to implement these measures as required. So this effectively means for South African government, once again, is that it is reminded and it's established beyond any doubt that it has failed its obligations, both domestic legal obligations and its international legal obligations, in failing to arrest Omar al-Bashir. It was a shameful failure and one which the government needs to own and move on to ensure that it constructively engages moving forward with the ICC. And secondly, it's also a strong message to many other member states like Jordan, most recently, who have failed to arrest and surrender Omar al-Bashir, that any claim of immunity that Omar al-Bashir enjoys, whether it be under customary international law or by application of any other domestic rights, does not exist. So it's established firmly by the judges, obviously with different views on this regard, that Omar al-Bashir does not enjoy immunity from prosecution under before the ICC.
Now, where could South Africa go from here? Is there perhaps, being an apex court, is there any sort of review if they are unhappy with this very ruling? Is there such a possibility?
Well, we only heard the summary judgment, and I'm now talking to you stepping out from observing the trial proceedings. The court might indicate a lift to appeal for South Africa, and if it does so, then it means that the government can appeal this decision to the ICC's appellate chamber, which will render a final judgment on the matter. That I'm yet to see if indeed the court has the majority or the unanimous views of if there's any lift to appeal for South African government.
What I found interesting, though, was their explanation of the Genocide Convention, or at least the obligations of Sudan. Can you just take us through that?
Yeah, sure. So this is a reasoning as outlined by one of the judges who entered his dissenting opinion, and his argument is actually establishing one additional grounds as to why Sudan or South Africa cannot claim immunity for Omar al-Bashir. Effectively, the court's argument is that given that Sudan is state party to the Genocide Convention, by application of that and by ascending to the Genocide Convention, it has waived any personal immunity to any individual in its territory that it enjoys any immunity under domestic law. So it effectively means that Sudan was under obligation by application of the Genocide Convention, which is state party to arrest and surrender Omar al-Bashir to an international tribunal. Given that Sudan is a member state of the Genocide Convention, it effectively means that when Omar al-Bashir comes to South Africa, he does not enjoy immunity as per the Genocide Convention as well, and hence it's an additional ground as to why South Africa, which is also a member of the Genocide Convention, should have understood its obligation both under the Rome Statute and the Genocide Convention to arrest and surrender Omar al-Bashir.
Thank you very much. That's Director at the Amnesty International, Natsanet Belay.